Hi, everyone. Thank you for joining us over your lunch hour today for another one of our WESC webinars. Um, my name is Lola Adebogan, and I'm WESC Marketing and Admin Assistant. Our topic today is partnership and shareholder agreements. What, when, and how. This is the fourth part of our five-part webinar series titled The Top 5 Legal Matters for Entrepreneurs to Consider. The last topic in this series will be taking place next week, Wednesday. And while I'm talking, I'll leave this slide up. I'll leave this slide up that shows the last topic in the series. Registration is now open up for it. Today's webinar will be presented by Frahiba Jalal, who is an associate at W Law Group. If you have any questions for Frahiba as we go through the presentation, please feel free to submit them in the Q&A box, not the regular chat box, just so it's easy for us to manage the questions. However, do feel free to use the regular chat box to introduce yourself and tell us a bit about your business. And as always, this webinar is being recorded and will be available for on-demand viewing. You'll receive an email tomorrow at this time with a link to the recording. With that, I'll pass it over to Frahiba to now begin the presentation.
Thank you, Lola. Hi, everyone. My name is Frahiba Jalal. I'm a lawyer with W Law here in Saskatoon. I'm very excited to be here today and presenting the second last webinar in this 5-webinar series. A little bit about myself. I work in Saskatoon as a lawyer in the areas of corporate commercial. So I work a lot with small and medium-sized businesses from the start of the business, incorporating them to helping with any types of business-related agreements clients might need, or any other legal issues that they may face during their business. And then I also do M&A work. So in terms of purchase and sale of businesses, I help clients with that as well. The other area of my practice is estate planning and estate administration. So I help clients sort of do their draft their wills, powers of attorney, healthcare directives, and advise them in how to best plan their estate. And I help executors manage estates once somebody passes and their executor takes over. I also help in the financial services area where I work with banks and borrowers. So whenever you're taking a commercial loan, usually, most likely, there's a lawyer involved helping with that transaction, and that's where I practice. Okay, as Lola mentioned, this is a 5-part webinar series, and I believe all the other ones are done except this one and the last one that's coming up on employment law. Our law firm was very excited to set this up with WESC. We figured some topics that were relevant to small businesses and startups would be really useful. So I hope you have some good takeaways from these webinars. Okay, so in terms of our discussions today, we'll be talking about partnership agreements and unanimous shareholder agreements. I did the first webinar on business structures, where we talked quite a bit about partnerships and corporations. So I figured during this webinar, I'll touch sort of on the basics of partnerships and corporations in case you missed a seminar, or just as a refresher. We'll just do some basics, and then we'll get into each of the partnership agreements and unanimous shareholder agreements and sort of talk about the main provisions and why they're there, why they're important, and all of that. If you have questions, as Lola mentioned, feel free to type them in the Q&A box and I should be able to see them. I'll try to answer the questions during the webinar as I'm presenting, so feel free to type in your questions. I'll also have time at the end to address any other questions you might have. Excuse me. Okay. So first of all, why have these agreements in place? I mean, lawyers are not cheap, and usually these agreements are drafted by lawyers. And again, these agreements are not cheap. Usually if you have a partnership agreement or a unanimous shareholder agreement drafted, it can cost minimum $1,500 to $2,000. And the cost can go up depending on how complicated it gets and how much you agree with your partners or other shareholders on certain terms, or how much negotiation goes on. So it can be expensive, especially for a small business or a startup. It can be a big concern where your legal budget is probably not very much. But in terms of their usefulness, they're very, very useful and they're highly recommended. So I thought we would talk about some of the reasons why you would want these agreements in place. So without agreements in place, partnership agreements or unanimous shareholders agreements, the law, at least in Saskatchewan, there's the Partnership Act that applies to partnerships and the Business Corporations Act that applies to corporations. And also common law, which is just a body of case law that's been developed, and that's how a lot of our laws have been developed in Canada. If you do have an agreement in place, the laws still apply, but you can use the agreement to sort of deal with matters that are not within the scope of the legislation, or to change the terms that would otherwise be the default terms from the legislation or common law that would apply. So that's where the agreements come in. They also help you sort of in advance agree to certain situations and certain terms before conflicts arise. So it's a really good opportunity, because a lot of times when you have just started a business, it's very exciting. Everybody's getting along. Your partner or the other shareholders, you think, we'll just see how things go. We'll go with the flow. Everything is great. And that's a really good time actually to sit down and talk through some of these terms and some of these scenarios that might arise later on in your business relationship. And when things are great and you're getting along, it's a really good time to hash out those details and agree on them. And that way, when conflicts arise or those scenarios arise, you have these terms that you've already agreed on, and it would be a lot cheaper to resolve conflict. In some situations, it wouldn't cost anything. You wouldn't need lawyers to get involved. And there would be a lot less disruptions in terms of your business operations, because if shareholders are not getting along, and a lot of times these shareholders or partners are the ones that are running the business, then there might be quite a bit of interruption in your business as well. So these agreements sort of help avoid a lot of that. And in terms of scenarios that I want you to think about would be things like a death of a shareholder or a partner, bankruptcy of one or other shareholder, divorce from a spouse, somebody wants out of the business, either they want to sell their shares or partnership interests to somebody else, or they want the other partners or shareholders to buy them out, or you want to force somebody out. So, and we'll talk about all these scenarios in quite a bit of detail, but these are some of the common things that these agreements help with. And again, if you have these terms and issues resolved by way of an agreement in advance, the cost would be a lot less than if you end up having disputes and having to hire lawyers to go through a court process or even just to negotiate, it can add up quite a bit. I should also mention, because partnerships, they're not the same as corporations, they're separate, different legal entities, but a lot of times, a lot of the things that are in the partnership agreements and unanimous shareholders agreements, they're very similar. So when I keep saying partners, a lot of times I'm just referring to your business partner, whether it's a shareholder relationship or a partner relationship in terms of a partnership. Okay, so just to touch base on partnerships, what are they? Partnerships are basically two or more people combining their resources to start a business with a view to make profit. Now, whether you make profit or not, that's a separate issue, but the plan is to start a business to make a profit. Usually partners are involved in the management of the business. Especially in smaller businesses. It might be that all of the partners are involved or some of the major partners are involved in the management of the business. But partners all are responsible for all of the debts and obligations that come up in the business. And the responsibility is joint and several, which means you are responsible jointly with your partners for the entire amount, but also alone for the entire amount of the liability that might come up in the business. So that's a very important thing to remember in terms of liability of a partnership. And you also assume responsibility for consequences of your partner's actions. So if your partner goes and signs a deal with somebody, gets into a contract, even if you didn't really agree with it or plan to do that yourself, you're still responsible for the consequences of that contract, for the fulfillment of that contract. Like I said, partnerships in Saskatchewan are governed by Partnership Act. They're very easy to set up, sort of like a sole proprietorship. You don't need a lot in terms of starting a partnership. You might register your business name, get a business license, and pretty much you can get started with at least one other person and start a partnership. So startup costs are low. You have additional sources of income in the form of other partners that can come into the business. Disadvantages are unlimited liability, as I mentioned. All of the liabilities of the business are your personal liabilities. There can be lack of continuity if a partner dies or leaves the business. And the biggest problem can be the conflict between partners as the business grows. And especially given that partners can bind each other legally, you are responsible for everything your partner does. That can be a big issue a lot of times and can cause more conflict in the partnership. Okay, so partnership agreements. They're not required at all under the law to start a partnership or to operate as a partnership, but of course they're highly recommended. Without an agreement in place, like I said, the provisions of the Partnership Act would apply and common law would apply. You can use partnership agreement to contract out of some of the provisions that are already in the Act, or to deal with matters that are not addressed in the Act or in common law. So getting into the provisions of partnership agreements, one of the main parts that you'll see in an agreement would be sort of the description of the partners. Who are the partners? In smaller businesses and small partnerships, it's usually individuals that form partnership. But it's also possible that the partners themselves are corporations, and then each corporation comes in as a partner to form the partnership, or at least one or two more partners might be corporations. And there will be also a description of the partnership interest, so how much each partner owns in the partnership. If it's the default 50-50, if it's just two partners, that is described, but there might be times when the interest might be different. One partner might have majority interest. There might be more than 2 partners. And so there's a description of how many units or how much partnership interest is held by each partner. And there's a description of the nature of the business and the name of the partnership. So the name that it will operate its business under and the place of business. Term of partnership. So partnership can be for a fixed term. You can specify in your partnership agreement that it will be for 2 years. And at the end of that term, the partnership is terminated. Or it can just be a partnership that continues until terminated by partners. There may be termination clauses in there, how a partnership is terminated, and there would be notice provisions if a partner wants to terminate the partnership. Funding requirement. So a lot of times the reason you bring in a partner into your business really is either because you need more money, so you need capital invested in the business, or you need expertise, certain expertise, and that partner can offer those expertise. But as you start and operate the business, you may need more capital. Oftentimes you do need more capital. So partnership agreements at times include clauses that talk about when partners would be contributing additional capital to the partnership and to what extent. It might just say that everybody contributes to the extent of their ownership in the business, or it might only have provisions about certain partners contributing capital. Ownership of partnership property. So partnerships are not separate legal entities. They can't own assets in their own names. So partnership assets are held in the name of partners. And so partnership agreements would specify if all partners will jointly own a property. So let's say there's land, whether everybody's name would appear on it, or if one of the partners would own all of the property. But either way, the property, if it's a partnership asset, it would be held in the name of the partners as specified, but for the partnership. So it would have clauses to deal with that. So I mentioned how in a partnership, you are responsible for all of the liabilities of the partnership, and also for consequences of your partner's actions. And you can't really contract out of it, but what partnership agreements do is sort of have indemnity clauses where partners agree with each other that they would indemnify, basically make you whole if you end up incurring a loss because of a liability. So let's say you are 50-50 partners in a business, and there's a $100,000 loan that you alone end up having to pay back. In the agreement, your partner would have agreed that they would cover you for their share of that liability. So you would have an action if there's proper indemnity clauses in the partnership agreement. You would have an action or a claim against your partner for their share of that liability. So it does sort of help minimize liability a little bit there. There would be clauses in terms of profit and loss allocation and distribution of profits. So whether profits are distributed at a fixed rate, it could be based on everybody's partnership interest. So if you're 50-50, you each get half the profits and so on. It could be based on how it's determined annually, and it could change. And there might be formulas for calculating profits and how profits are calculated and how loss is allocated. A lot of times, again, you are responsible for all the liabilities, but in the agreement, there might be a clause that says the expenses are allocated or the losses are allocated based on your partnership interest and how often profits are distributed. All of that can be addressed in the partnership agreement. So as I mentioned as you operate a business, oftentimes you end up needing additional capital. So in addition to partners chipping in and contributing additional capital, some businesses end up having to borrow more money. So partnership agreements can include clauses dealing with borrowing powers of the partnership, whether the partnership would be allowed to borrow. Sometimes there is specific limits up to what amount the partnership would borrow from a third party. And there would be clauses in terms of giving of security. So security basically means pledging a collateral. So if you're borrowing $100,000 from the bank might require security to secure that. So again, a lot of times if there's partnership assets that can be used as collateral, that's great, but at times partners might have to use their own personal assets as collateral. So the partnership agreement might have provisions dealing with partners' ability to give security, and when or how, and it would deal with whether other partners would be responsible equally for those liabilities. Management of the partners. So some partnerships are big. You might have quite a few partners, so only one or two partners might be involved in the management. Some partnerships are smaller and all the partners are hands-on and they're involved in the management of the partnership. And again, with very small businesses, startups, everybody's involved and they're doing everything. But you could include provisions in the partnership agreement that formally describe the roles of partners, who does what in terms of the management of the partnership. You might even agree on committees that can be set up. And some of these things might not be happening at that time in your business, but you have to also think long-term in 4 years, 5 years, 10 years down the road. If you're planning on your business growing, then how would the business be managed? Who would be responsible for the management? You may have committees for different types of responsibilities in the business. It would deal with meeting procedures for the management committee. So how often, what kind of quorum, what's considered quorum, where do they meet, all of that. There might be a managing partner, and I've added general partner, but general partner basically is appointed in limited partnership scenarios where I haven't covered limited partnerships in this webinar, but we've talked about it in our previous webinar. So anyway, it would be a managing partner or general partner, how they're appointed, how they're removed, what their roles and responsibilities might be. There might be provisions in terms of what kind of decisions need special majority, so more than 50%, or even unanimous agreement by all partners. So there would be at times limits on the role of the management group and what kind of decisions they can make if not all partners are involved in the management, but all the partners would want to be involved in voting on certain decisions when it's big decisions, let's say the solution of the partnership, or taking out a very large loan, or purchasing a very expensive asset, things like that. More partners might want to be involved in those decisions. So the other provisions, and these provisions are very important in the partnership agreement, would be scenarios dealing with retirement of a partner. So whether it's retirement because they want out of the business, they want to sell their business, death of a partner, bankruptcy of a partner. So just for context, the Partnership Act in Saskatchewan says that if a partner dies or files for bankruptcy, that the partnership is dissolved. And the remaining partners most likely, in most situations, wouldn't want that. So the partnership agreement sort of deals with what happens when a partner dies. You can think of a scenario where your partner dies. If you don't have anything in your partnership agreement, then the estate law would apply in that situation. So if your partner dies, they have a will that says everything I own goes to my spouse or to my 5 children in equal shares. You might find yourself now in business with your deceased partner's spouse, or worse, 5 children. So it's not always the ideal situation. And a lot of times partnership agreements say that if a partner dies, the remaining partners have the first option of purchasing that partnership's interest from the estate. And the purchase is done most often and for fair market value, and that's all in the partnership agreement. So that way you can protect yourself from that uncertainty in terms of who you would end up in business with. And same thing with bankruptcy. If somebody files for bankruptcy, all of the assets are then taken under control by the trustee. So then the trustee can dispose of those assets. And so you don't want the partnership interest being sold to a third party that you don't know and don't want to be in business with. So it deals with those situations. And so these provisions are very important. The provisions provide for the buyout price. Like I said, usually it's at fair market value. And there would be procedures in terms of how the fair market value is determined. Sometimes it's determined at the time by partners. At times it's determined by a valuator, or there's a set formula for it. So a lot of times you agree on all these procedures before any these scenarios happen, and it all goes into your partnership agreement. So you have some certainty going forward during your partnership in terms of what happens if your partner dies or if they get divorced, for example. Divorce is another big one. Partnership agreements deal with scenarios where if somebody is going through divorce and there's a court order against dealing with applying to that would be applicable to the partnership interest, that in that situation, then the rest of the partners would have the option to just buy him or her out. And that way you don't have to find yourself having to be in business with your partner and his or her ex-spouse shareholder or partners, especially when they're not getting along. So very important provisions to think about and make sure you have in your partnership agreement. Restrictive covenants, you might have heard of non-competition and non-solicitation clauses or agreements. So that's what the restrictive covenants are. Usually you have these in the agreement, and they apply to when a partner leaves the partnership, especially if the partner is very involved in the running and operations of the business. And these clauses restrict that ex-partner's ability to go on and open a similar business down the road or start soliciting your clients or your employees. There's time limits on that, and location in terms of the geography, there's limits. You can't have it forever, that kind of restriction on somebody, but it helps in the immediate few months or a year or two of the departure of that partner quite a bit. So very important provisions again. Okay, and partnership agreements, again, also have provisions that deal with transfer of partnership interests and the solution of the partner. So the solution is when you're winding up the partnership and dissolving the partnership. And oftentimes the partnership agreement would have specific triggering events when a partnership would be dissolved. So whether you put a definite term, and usually it's the same as the term of the partnership itself. So you have a definite term, 2 years, 5 years, whatever, or end of a project. So if you started the partnership for a specific project or venture, once that project ends, you dissolve the partnership, or partners vote on the solution of the partnership. And usually for in partnership agreements, in order to dissolve it, either all partners have to agree or a great majority of them have to agree. So you decide on that. And then in terms of transfer of partnership interest, you know, if somebody's buying you out or you're buying them out because they died or they want to just be out of the business and all that, there's procedures on how that will happen, you know, notice procedures, the fair market value, how long for the sale or transfer to be complete, because again, it gives you a lot of certainty. So you're not wondering whether it would take a year or 10 months for this to be complete. So the partnership agreement includes all those procedures. And then on dissolution, it would have clauses in terms of how the assets are ascertained, how the assets are disposed of, how settlement with creditors are done, because all the liabilities have to be addressed before you can wind it up, whether former partners will continue to have any obligations and all of that good stuff, how the net assets are distributed. So there's all these procedures dealing with them, and again, very important provisions in the partnership agreement. And I should mention, these are sort of the main things. They're not all always included, and sometimes there's additional provisions depending on what your and your partner's needs are and what the nature of the business is. So these are the common ones that we see and we've included, but there's always variations. Okay, now moving on to corporations. Just to touch base on what corporations are. In Saskatchewan, they are governed by the Business Corporations Act. When you incorporate a business or you create a corporation, you're basically creating a separate and distinct legal entity where they have a separate, and the corporation has a separate and distinct legal entity from their owners. So a corporation can own assets in its own name, go into debt, enter into contracts, sue, be sued, all of that stuff. They have an unlimited life expectancy, so they can continue forever without, even if shareholders keep changing. Think of these giant corporations that have been around for decades and decades. Shareholders would have changed many, many times. The ownership of a corporation changes with transfer or issuance of shares. And so that's why the owners are called shareholders. And the shareholders have limited liability to the extent of their investment in the corporation or business. And the corporation has limited liability to the extent of its assets. So if somebody is suing the corporation, it can't also sue the shareholders unless under very, very, very limited circumstances, if they're also directors and whatnot. But in most situations, they can only sue the corporation and they can only recover against the assets of the corporation. So that gives quite a bit of liability protection for shareholders, and it's a very attractive feature of a corporation. Okay, there might be possible tax advantages depending on the size or revenue of the corporation and where they're incorporated. Easier to raise capital, so you can bring in new shareholders. They're very closely regulated and they're expensive to form or set up because corporations would need, you need to incorporate and do all the corporate registry filing. You have to have bylaws and articles and all of that. Usually is done by lawyers. You need to do annual returns or annual returns, but also annual tax returns, and all of that costs more money. So sometimes from a savings perspective in terms of taxes, it's not always as advantageous, especially in the beginning stages. But from a liability perspective and other reasons, it can be pretty advantageous. So unanimous shareholder agreements, and we call them USA for short. You might have heard of just shareholder agreements or unanimous shareholder agreements, and sometimes they're used interchangeably, but basically unanimous shareholder agreements are signed by all of the shareholders at the time of the corporation. They bind future shareholders. So there's provisions in the USA that says any future shareholder that comes in has to sign and agree to all the provisions of this agreement. Again, just like partnership agreements, they deal with matters beyond the scope of the legislation, or you can change some of the terms that would otherwise be applicable from legislation. It's sort of the go-to document for governing the relationship of the shareholders. Like partnership agreement, it really deals with the relationship amongst the shareholders. Again, a really good document to have, especially in smaller or closely held startup companies, where they don't have the resources, and the shareholders personally also don't have the resources to hire corporate lawyers and litigators to resolve conflicts that might arise down the road amongst them. And it's just like partnership agreements, at the onset, you kind of clarify some of your expectations and agree on some of these terms before conflicts arise. So again, it can help sort of avoid some of the conflict and also avoid some of the business disruption because of the conflict that might arise. So a lot of the provisions that I addressed in the partnership agreement are also quite common in USAs because the structure is very similar. So some of this might be a little bit repeated. I'll try to talk about other things, but they can be quite similar. So for example, governance and control is sort of that management provision in the partnership agreement. In corporations, shareholders are owners, and then you have directors that manage the day-to-day affairs of the corporation. And directors, again, can be shareholders. In very large corporations, shareholders are not always the directors. You have other directors that come in. And even if shareholders are directors, they're not always all of them directors, depending on how many shareholders are out there. So the governance and management control provisions deal with how directors are appointed. A lot of times shareholders all want to have a say in appointing the directors. So they get nominees, for example, that they can use to appoint as directors. And if there's going to be committees, who the committees would be and what kind of committees would be, and also how directors are removed. So for minority shareholders, these provisions are very important because they might want to have a say in who becomes the director of the corporation. There would also be description of powers of directors, and oftentimes restriction on powers of directors. So whether some of the shareholders are directors or none of them are directors, and directors are non-shareholders, in most scenarios, all shareholders want to have a vote or a say when it comes to certain decisions. So again, minority shareholders might want unanimous agreement on certain matters. Let's say, again, a big loan that's being taken out, or winding up of the business, or changing the nature of the business, things like that. And majority shareholders might just want supermajority or just majority, because they don't want to have to go to minority shareholders to agree on some of these. But either way, oftentimes there's restrictions on powers of directors in terms of which decisions have to be approved by shareholders, whether it's majority or supermajority or unanimous, shareholders have to decide on that. Funding considerations similar to partnerships, whether shareholders are expected to contribute additional capital beyond what they've invested in the business when buying up, whether they are expected to give security and sign personal guarantees, because personal guarantee, a lot of times, again, especially with a small business, the bank's not just going to give a big loan to the company, knowing that the company may not have assets. So they would require shareholders to sign personal guarantees and even pledge security, oftentimes their own personal assets. So there might be provisions in the agreement that say whether shareholders are expected or whether nobody will be asked to do this. Okay, now some of the rights in terms of transfers of shares, and these, some of the names are confusing, but I will just mostly focus on the concepts and what they address. And again, when we're talking about these, think about it from a minority or a majority shareholder perspective, because then you're your preference might change depending on what your stake is in the business. So the preemptive rights basically deal with issuance of additional shares in the corporation. So if, let's say, there's 100 shares of the corporation that's been issued to all the shareholders, and you own 30 of those shares, so you own 30% of the corporation, you don't want the corporation to, down the road, issue another 100 extra shares to somebody else, because that would really dilute your 30%, right? So a lot of times there's restrictions on issuance of new shares, and other shareholders would want the right to the first option to purchase those additional shares so that they can protect their own interest. Right of first offer refusal, basically if a shareholder wants out, a lot of times the other shareholders might want the first right to buy that exiting shareholders' shares. And again, a lot of these are done on fair market value basis. But those provisions deal with what happens if a shareholder wants out and whether other shareholders would have the option to buy that shareholder. Piggyback back and tag along. This helps minority shareholders. So if you only have 10% or 5% in the business, and the other shareholder that owns 90% goes out and finds a buyer that wants to buy their 90%, you might not want to end up having to be in business with a new partner, a new shareholder. So these clauses give the minority shareholders the option to sort of piggyback on that sale and say, okay, you're buying my 10% as well. Okay, sorry about that. Drag along rights, this is the opposite of the previous one. So this protects majority interests and majority shareholders. So if you are the 90% owner and you suddenly want to sell the business or sell your shares, most buyers would want to buy up the whole company, not just your 90%, and have to deal with this other minority shareholder. So this allows you to drag those minority shareholders along with you on that kind of sale. It helps you get a better deal for the sale of the business. Buy-sell provisions, similar to the provisions I talked about in the partnership agreements, death, divorce, disability, termination of employment. So that would apply if a shareholder is also an employee, and that often happens when an employee is brought on and given stock option. So if their employment ends up being terminated, you don't want them to own shares. Fraud, bankruptcy, breach of USA, these are sort of called events of default or triggering events that allow buy-sell of that person's shares. So again, think of if you don't have anything in the agreement and you're a shareholder, if you die and your will says all your shares go to your spouse, then it will go to your spouse. But oftentimes in USAs, the shareholders agree that if somebody dies or become disabled where they can't continue with their role in the company and bankruptcy and all that, then the company, the corporation itself gets the option to buy up their shares, or the other shareholders have the option to buy up those shares. Again, a lot of times fair market value, sometimes there's a discounted price, but either way there's provisions to prevent shares ending up with somebody that other shareholders don't want, or to kind of take away the uncertainty in terms of what might happen if a shareholder dies or files for bankruptcy. Now, somebody had sent in a few questions that I will just sort of quickly address here. One was, well, the first question was whether there's a standard USA form which can be adjusted and changed. And the answer to that is not really. Each law firm and lawyer, if they're doing a lot of these USAs, they sort of have their standard agreement, and that's why they would charge you their minimum price. And then they kind of go through all these clauses with you, and then if you want to change things and adjust things, then that gets done that way. And then the second question is, upon death, do shares go to the other shareholders? And the answer to that is, it depends on whether you have a shareholders agreement in place or not. And if you do, whether it says that it will be bought up by the other shareholders. So they don't just get it, they still have to pay your estate, and what they pay is sort of determined in the shareholders agreement. And then there was a question about how to ensure that my shares go to my children and not other shareholders. And again, that's something, if you have a shareholders agreement that you have agreed that your shares will be bought upon your death by other shareholders, then you can't really transfer them to your kids. But if you don't have that, then you can put it in your will that everything you own goes to your children. And then the last question was about a company that was incorporated some 36 years, a husband and wife, they're going through a divorce, and how to protect the shares. And for that question, I encourage the participant to maybe talk to me offline, because I have some additional questions on that, because if it's just two spouses operating for so many years, presumably you are 50-50 owners. And then if you're going through a divorce, most default position is that everything gets split 50-50 anyway, so that might apply to your shares in the company as well. But in general, shareholders, USAs have provisions that deal with what happens if a shareholder is going through divorce and there's an order against the shares. So again, other shareholders would have the option to buy those shares. Shotgun provisions, sort of these exit provisions, you might want to, this basically allows one shareholder to give the other shareholder an offer and say, I'm buying up all of your shares at this price, and if you don't accept my offer, you have to buy all of mine at that price. It basically, those situations where the shareholders just can't be operating together, so you just want to have a mechanism for one of them to end up in the company and the other one to be out. And again, it's not so advantageous for a smaller shareholder that might not have the capital to buy the other shareholder. So you're left with agreeing to just sell your interest, basically. Valuation, again, it deals with what the value of those shares that are being bought or sold will be, whether it's agreed at the time by the parties or there's a formula, or whether a third-party valuator is appointed to figure out the value. It depends on the complexity of the business and the revenue and all of that. Again, that can be included in your agreement. I have a question that I'll check. So the question is, when offering stock options to employees, what clauses should the USA include? This should be built into the USA when it's first developed or later, or is the USA separate and a separate agreement signed regarding employee stock option? So oftentimes when you do a stock option, you have an employment agreement for that employee, and it says it includes a stock option provision and how the option would be exercised, at what price, all of that. Sometimes it can be included, sort of that additional possible stock option that would be issued, but it's a lot more appropriate to deal with it in a separate employment agreement and stock option agreement. But the USA could include, would include provisions in terms of, additional share issuance and if you were anticipating that you would have employees that you would offer stock option, then you might want to have provisions built into the USA that allows that. That way you're not having to amend your USA later on. I hope that answers your question. Okay, so some of the other clauses, confidentiality of information, shareholders might agree that they would keep the information that they come across confidential, especially if they're involved in the running of the business. Non-compete, non-solicitation clauses, very similar to partnerships, especially if the shareholders are very much involved in the running and operation of the business. You might want to restrict the ability of the exiting shareholders to go and start a competing business across the street, or to get your employers or clients and solicit them away from your business. again, there will be limits in terms of the geography and how long you can have a clause like that. Dispute resolution, a lot of agreements, partnership agreements, shareholders agreements, a lot of contracts actually have dispute resolution clauses. It's basically a way to avoid having to go to court. So it says if there's a decision that they can't agree upon, then what happens, whether they would go through formal negotiation and mediation or arbitration. Each one is a bit more formal. Whether they would have an arbitrator or mediator appointed and who would appoint them, how they would be appointed, who would pay the cost, all of that. Okay, I think that's what all of the clauses. And again, just like partnership agreements, these are the main provisions that usually go in the USAs. They're not all the provisions, and not all of them are always included, especially if shareholders are having a hard time agreeing on some of these. They might want to scratch them out completely and then have different provisions. So not every USA is exactly the same. That's why the cost can sometimes be different depending on where you end up in terms of your agreement with the other shareholders. Okay, just to sort of wrap up in terms of our discussion on partnerships agreements and USAs, they're both very crucial when operating a business with others. Unless you're operating a business by yourself, there's a really high likelihood that you would have some conflict and dispute with your partners or other shareholders. So these agreements can be quite important in avoiding some of that conflict or minimizing it. It's a really good opportunity for the partners and shareholders to sort of from the start sit down and talk about some of these terms and maybe even see how you deal with conflict before real conflicts arise. You can use the agreements to opt out of some of the provisions in the legislation. They can be a lot cheaper than litigation and also save a lot of cost to your business when there's business interruption because of conflict. And they deal with, I mean, we talked about a lot of the provisions, but generally they deal with scenarios where there's an exit of a partner, addition of new partners or shareholders, transfer of ownership amongst partners or from one partner to a third party, and allocation of profit and loss and etc. I think that wraps up all of the information I wanted to give you. So if you have any questions, feel free to start typing your questions. I'll be here for a bit and I'm happy to answer your questions.
Thank you, Fahiba, for that fantastic presentation. It was very informative, and I know it's going to be a great resource for entrepreneurs in the future. And for those of you who took time out of your busy lunch days to join us, don't forget to check our events page at west.ca/events to register for our upcoming webinars. Our next webinar is happening next week, Wednesday, January 27th, and it is titled Employee or Independent Contractor, Why It Matters. Our presenter will be Kim Osmowak who is an associate at W Law. Registration is open on our website. We hope to see you then. And if there are no other questions, I will end this webinar. I'll just wait a little bit. There's none. Okay, thank you all and have a wonderful day.